In today's stupid article time, we respond to an article from the Los Angeles Times that says that the 303 creative website decision, which says that, hey, people have freedom of speech and you can't compel that speech, compelled speech is bad, could swamp all civil rights legislation. Well, Los Angeles Times, not to put too fine a point on it, but all civil rights legislation is, by its nature, legislation. They are acts of Congress, which, is great and all, but the Constitution itself says the Constitution is the supreme law of the land. So, yes, to the extent the First Amendment trumps civil rights law, the First Amendment trumps civil rights law. I know, it's amazing. The Constitution, which says it's the supreme law of the land, is necessarily supreme to all civil rights law because that's the nature of what it means to be the supreme law of the land. Permanent, preeminent, of more importance, greater priority. Yeah, yes, to the extent the First Amendment trumps civil rights law, it trumps civil rights law. I know, amazing. Constitution for the win. Let's respond to this stupid article time from the Los Angeles Times. The Los Angeles Times writes, now that the legal door has been opened to anti-LGBTQ plus bigots or racists, and I will note right away, by the way, Los Angeles Times, not for nothing, but you are somewhat misquoting the opinion because the opinion only talked about LGBT rights. So I'd like to take note that you apparently have a disagreement with the Supreme Court already, even the minority opinion, by the way. So maybe you should be writing how Sonia Sotomayor is a super, super bigot because she doesn't recognize Q or plus, apparently. But whatever, pressing on. There's no telling how far Supreme Court license to discriminate will go. I know the answer to this question. It will go as far as the First Amendment goes. It's amazing. Wow. So yes, you have the power. Private people have the right to discriminate because the Constitution doesn't apply to private people. It only applies to government. Private people can discriminate. Statutes can prevent them from discriminating, but the First Amendment trumps. Like, for example, freedom of religion, for example, is very discriminatory by its nature. Because when you have freedom of religion, you don't want to, do other religions. So should there be discrimination on the basis of religion? Well, if you're a religious person, then kind of very much yes, because you naturally want to practice your religion and not others. It's amazing. I know. It's shocking and true, but the Constitution recognizes the right to make choices. It's super deep. Last month, the court's conservative majority, super right-wing, I'm sure, ruled that a website designer who, by their nature, is producing speech would not have violated the state's anti-discrimination law if she refused to create a wedding website for gay couples, because she's refusing to create a website which is by its nature pure speech. It's pure speech. It is non-utilitarian. It merely provides information. Information is not technically useful. It is merely providing information and pure speech. So, they say I don't want to provide the speech because I don't like to provide that speech. So, yeah, she doesn't have to provide that speech. It's true. Mind you, Lori Smith, the proprietor of 303 Creative, was not actually creating wedding websites at this point, but she wanted to know in advance whether it would be okay to turn away gay people because she abhors same-sex marriage. Well, it's not exactly turning away gay people. That's the thing. According to the stipulated facts, which, by the way, you seem to have no interest in, she said that she would, in fact, serve gay people who wanted her services. She just wouldn't create speech that says that, gay marriage is good, which is sort of implicit in a website. So she will provide graphic design services and web design services to gay people. She just doesn't want to provide the services that say, I like gay marriage, which is implicit in a gay marriage website. Smith is represented by the right-wing Christian legal juggernaut, the Alliance Defending Freedom, which is hell-bent on reversing the LGBTQ plus rights. To Smith, her lawyers attested same-sex marriage is not only problematic because it violates God's will, but because also it harms society and children, because marriage between one man and one woman is a fundamental building block of society and the ideal arrangement for rearing children. Well, that sounds like an opinion. Some people may not share that opinion. It's okay. You don't have to share that opinion. If you disagree with that opinion, you can express your own opinion using your own speech. That's fine. You just can't compel her speech. You can't force her to speak the words you disagree with. I know, it's amazing. In telling their client story, the ADF laid it on thick. Oh boy, they laid it on thick. Are you sure they are the ones laying it on thick and not you? This seems a little bit thick to me, but okay, continue to lay it on to me. Laurie believes that our culture's movement away from God's design for marriage is particularly pronounced in the wake of Supreme Court's Obergefell versus Hodges decision, which held there's a constitutional right to same-sex marriage. Yeah, okay, so she thinks that, the culture is heading in the wrong direction. She seems to be a Christian who actually, believes in this stuff and thinks that this is not what marriage is supposed to be, which is a pretty uncontroversial opinion, at least if we go back in time, let's say, I don't know, 30 years ago. It was a pretty uncontroversial opinion. I thought it was bizarre to be able to bring a lawsuit with imaginary facts. But as the Berkeley law dean explained to me, federal law allows for it, especially if the situation seems likely to arise. Yes. So, there is such a thing as a pre-enforcement challenge, particularly in the First Amendment context, because the Supreme Court and the federal courts are particularly interested in freedom of speech issues because, we consider it probably the most important constitutional right, which I tend to think is true. The right to speak is the right to think. And the right to think what you want is the right to be able to believe and have your own opinion. So the right to speak is the right to think. And, you can, in some situations, bring a pre-enforcement challenge. So simply because, it hasn't happened yet is not necessarily a bar, particularly in the First Amendment arena. So, yeah, no one should have to eat a mushroom in order to know if it's poisonous or not, the dean said. She said, I'm not going to set up this business if I have to serve safe subcapsules, so let me know in advance. Fair enough. Wow. I appreciate you conceding that point, that, maybe it would be okay for sometimes people to bring these suits. I know the pre-enforcement challenge is a little bit untypical, because the injury hasn't occurred yet. So we're talking about standing issues and whether or not you have enough standing because nothing bad has happened to you yet. But, you don't necessarily need the bad thing to happen. You can get declaratory judgment in advance. And you just need it to be certain enough, sure enough, that it's essentially imminent. And here she's like, I want to create a website. I've seen Colorado from how they've treated Masterpiece Cake. I have a pretty good indication to my mind that they intend to enforce the law this way, which, by the way, Colorado doesn't incidentally deny. They're like, no, we have no intention of enforcing this. They're like, yeah, we're totally going to do this. So the fact that it hasn't happened yet, well, it's not necessarily a bar and certainly not in this domain. As for reports that Smith made up the gay couple, she claimed contacted her for the wedding website services, even though she hadn't launched the business yet. She says the dean says it no longer matters. Once the court decides, you can no longer challenge the case. Yeah, so okay, let's talk a little bit about this issue, about this so-called made-up evidence, because the whole thing is a little bit bizarre. So the day after she filed the lawsuit, she apparently gets an email from somebody saying, would you create for me a gay wedding website? Now, at this point, she has not yet created any wedding websites, but she is a website designer. So she does create websites for other purposes. And she hasn't said, at least publicly that I'm aware of at this point, she hasn't on her website. Well, no, maybe she has. I don't know. But she's like, whether or not she creates wedding websites, but she creates websites in general. So the day after the website, she apparently gets an email. The day after the lawsuit. The day after the lawsuit was filed, she apparently gets an email from somebody saying, create me a wedding website, to which she didn't respond. Now, it has apparently come out after the fact that this man denies having sent this email. The law firm, for their part, that represented her is like, we didn't make it up because there'd be no reason for us to. Also, it came out the day after we filed the lawsuit. So we thought we had enough standing, incidentally, the day we filed the lawsuit. So we added it to it because, it's an additional piece of evidence, but it was always a pre-enforcement challenge. It was never based on she had received a request. At the time we filed the lawsuit, she had not received a request. So we didn't file the lawsuit on the basis that she had received the request. We brought it as a pre-enforcement challenge in the first place. So, there's that. So what's true behind this email? I don't know. Why some person other than him would file it with his specific information? I don't know. Maybe it's a prank. Maybe he did it and it's just denying it. I don't know. But it doesn't really matter either way because this was filed at a time when there were no requests at all. It was always a pre-enforcement challenge, which is a little bit rare, but not in the First Amendment arena. So, yeah. It will come as no surprise the Alliance Defending Freedom also represent the Colorado baker who won a limited Supreme Court victory after refusing to make a wedding cake. Well, that seems like a pretty good people to hire. There are people who are very, 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 very familiar with the issue because, they've lived and breathed the issue through Masterpiece Cake. So could another attorney do this? I would imagine, sure. But if you're looking for a person to do it, well, the people that already took Masterpiece Cake to the very end are a pretty reliable source. You know that they're going to represent you. And they're also extremely familiar with the law because they've lived and breathed it. It is in their essence. So yeah, she hired the same law firm or the same entity that helped to defend Masterpiece Cake because they seem like a good choice. It's amazing. Later, and I tell you to demonstrate the fears about repercussions of the Supreme Court sanctioned discrimination are not same fact. The same baker, Jack Phelps, found himself back in court after refusing to make a cake celebrating a gender transition. Yep. So after the whole wedding web cake where they kicked it back because they thought the Colorado courts didn't, or the administrative agency, more to the point, didn't sufficiently represent his religious rights, and this case is decided on freedom of speech grounds rather than freedom of religion's grounds, so it's a little bit different than Masterpiece Cake. Masterpiece Cake was brought primarily on religious freedom grounds. The Supreme Court decided it, such as they did, on religious freedom grounds. They're like, you showed animus to his religion at the levels below, which there was more than some evidence about. So yeah, they kicked it back, and then someone said, how about a gender transition cake? And he's all like, nah, fam, I didn't do the gay cake. I'm not doing the gender transition case. And amazingly enough, Colorado went after him again. What are the odds? What are the odds? Basically 100%, but yeah. So yes, he doesn't want to design the cake to spread a message about gay marriage or gender transition. He's not particularly fond of either one. Who will bake the cake? Literally anyone else, I would imagine, but we want specifically him to bake the cake because it has to be him, because I don't know, he makes just the best cakes in the world. I don't know. What he can and can't do remains contentious. The state appeal court found that he violated Colorado's anti-discrimination law. Well, yeah, but the courts are going to have to reconsider that in light of the Supreme Court's decision because, speech, and he doesn't want to be compelled to make speech. So Colorado apparently really into going after people for violating this law. So once again, when we're talking about standing of 303 Creative, we can't help noticing that Colorado seems to be really, really eager to prosecute all these people into forcing to speak the way that they Colorado wants. So I think that there's enough likelihood of prosecution. In my case, I can go forward. How so? Because the customer, Autumn Scarina, had simply ordered a pink cake with blue frosting. That design, the court said, had no message or imagery that could be construed as violating the baker's rights. Well, the baker doesn't quite see it that way. The baker doesn't quite see it that way, that it doesn't spread a message. So, he thinks it spreads a message, particularly because you told him it was to spread a message. So you're like, I want this specifically because of the speech it represents. So he's like, yes, this represents speech. That's not fair. That's not fair. It doesn't have any imagery. Well, you know who disagrees with that? The person who requested the cake disagrees with that. What are you talking about, court? Of course, they've appealed to the Colorado Supreme Court, who, probably will have to take a second look at that in light of 303 Creative. But apparently, the Court of Appeals thinks the cake doesn't have any message, even though the person apparently specifically requested it, specifically because of the message it would request. So, yeah. But back to the 303 Creative. Why, in this case, the Supreme Court said essentially, why? Yes, of course, Ms. Smith. If same-sex marriage goes against your belief, then by all means you refuse your service. The nature of the service is speech, sir. It is in the freedom of speech. This is not just any service. It is not just a simple good. It is not a useful article. It is not a utilitarian thing that has utility. It is not utility, okay? She's designing websites that have no utility. They have no useful purpose in a technical sense. All they do is spread information, which is not useful. So, yeah, she is supplying specifically a surface that goes directly to a core First Amendment interest. The court's opinion did not turn on the beliefs that arise from religion, because this was not decided as a freedom of religion case, but rather as a freedom of speech case, because that's more on point. The issue is not really, strictly speaking, her religion as such, but rather her forcing compelled speech. So she can't be forced to compel the website, which is not useful because it goes directly to her core First Amendment interest in freedom of speech, which does not have utilitarian value. Making a wedding website may indeed involve the maker creative expression. You think that a website might involve creative expression? You think LA Times, wow, that's genius. But what else falls into the category? In a wedding context, says the dean, it could be designing a cake, floral arrangement, stationery. In context, it could be a cabinet maker. All that's open. There really is no stopping point. Well, dean, not to put too fine a point on it, but this is why this case, as a pure speech case, was a better vehicle than Masterpiece Cake, because Masterpiece Cake dealt with an article that has utilitarian purpose. It is a cake. It is suitable for being eaten. It is suitable for providing nutrition. It is a utilitarian article. It has utility, right? So these other examples, like floral arrangement, stationery, cabinet making, right, get into this issue of blending a useful article with a speech. And how to separate that gets a little bit legally tricky. And the Supreme Court dissent talked a little bit about regulations that are incidental to speech. In the example of a cabinet maker, probably much more incidental, right? A cabinet is pretty utilitarian. It might be very nice, it might be very well created, but it's primarily a utilitarian article. And so separating the distinction can be a little bit tricky in some of these examples, but that's exactly why they brought this particular case, because it's pure speech and doesn't involve a useful article, because the website is not useful, because all it does is provide information, and that is not a useful article within the meaning of the law. So how does this deal with things that have utilitarian purpose? Unclear, but there is some case law dealing with it, and we'll have to deal with that on a case-by-case basis. Doubtless, determining what qualifies as expressive activity by the First Amendment can sometimes raise difficult questions. Yeah, that's fair. That's fair, especially when you're embedding the speech into the useful. Separating them out can sometimes be tricky. That's fair. You may not be able to define expressive activity, but undoubtedly know it when you see it. That's true, especially as you get a little bit more and more into the useful. Finding the speech and separating the speech can get more and more tricky. So fair. There is a bit of a line drawing problem. We have a bit more ability to deal with this as we are more into the pure speech arena and less into the useful arena. But as you continue trying to do it, it gets tricky. But that's often true in law. It's tricky sometimes on the borders. Tell me a lot of legal situations when that's not true, right? Trying to separate things sometimes gets a little bit murky in the middle. Tina says, whatever you're doing, don't stop. Enjoy seeing you smile more, and there's more calmness in your voice. Been watching you since Step Heard, and there's definitely a difference, and it's great. Well, thank you, Tina. That means a lot to me. I appreciate that. It has been an interesting ride. It's been a year since Johnny Depp, right? It's been a year. And in that year, a lot has happened to me, not the least of which, by the way, was me leaving my job, which was providing a lot of existential pressure on my depression. So as I've talked about many times, I suffer from depression. My job was a major external pressure adding to and aggravating that depression. So removal of that has been a significant benefit to my depression. The depression is still there, but fortunately it's not being aggravated all the time by that. Also, my recent workouts seem to have helped a little bit. My cardio is complete garbage, and I need a lot of help, and I'm definitely the fat ass of the gym, but then again, I'm kind of in the place I'm supposed to be, aren't I? The fat ass should be in the gym, so becoming not a fat ass, and so that seems to help. Did you know I worked out 13 times last month? I was surprised too. That was cool, man. I looked at my logs and I was like, wow, I was at the gym 13 times last month. I'm like, that's not bad. For various sick days and various times that I was at the gym 13 times in a month, I'm like, hey, that's some pretty good progress. We're making some good progress along the way. We're not doing too bad Uncivil. Things aren't great right now, but we're heading in the right direction. We're making progress. Things are getting better. Let's continue to make things better. Yeah, that's nice. Wow. The ACLU, staunch defender of the First Amendment, and while that used to be true, I'm much less sure it's true now, said the court got it all wrong. The case was not about free expression, but about discrimination. Properly framed, the ACL wrote, the question presented is whether an artist who has chosen to open a business to the public at large can constitutionally be prohibited from discriminating against customers on the basis of protected characteristics. That's not the proper way to frame the issue. The issue is the message they want. She's not discriminating on the characteristics, she's discriminating on the message. As long as they don't want that message she disagrees with, they can hire her all day long. That's in the stipulated facts, so that's not the right way to frame it. It is too soon to see exactly what ripple effects this unfortunate decision will have, but you can be sure it will be construed in many quarters as a license to discriminate purely on personal beliefs. Bah. That's not at all what the decision says. It's not even close to what the decision says. You are an idiot, LA Times. This is all about the First Amendment and freedom of speech. This is about compelled speech. Compelling speech is bad. You know, the LA Times, I would think, and this is the thing that continues to befuddle me when it comes to such things, is that newspapers like the LA Times seem to not understand this principle, because you would think if anyone would be interested in freedom of speech, it would be something like the LA Times. The LA Times is somewhat in the trade of speech. That's kind of all they do. The LA Times is also about as pure First Amendment as it gets. Not because they're special because they're press, which they're not. They're not special in that sense. They are, however, about pure speech as it gets, because there's nothing useful the LA Times does. And I mean that in both a technical and colloquial sense in this case. There's nothing useful about what they do. All they do is provide information, such as it is. But, you know, they are just... The fact that they don't seem to appreciate that that they don't value their own First Amendment interests is somewhat beyond me. I don't understand why they don't jealously, and I use that word in its technical sense, why they don't jealously guard their First Amendment and seem so willing to give it up is a little bit beyond me. I suppose the cause is even more important than their own First Amendment, which is amazing. As the Colorado Attorney General put it after the decision came down, a business may think it has the right to refuse to serve interracial couples because it believes interracial marriage is wrong. Well, to the extent it's pure speech, probably yes. Because, you know, discrimination on the basis of race is bad. You probably shouldn't do it. But to the extent it's pure speech, yeah, you probably can refuse to create a wedding website for an interracial marriage. You know, I wouldn't necessarily recommend it, but you could, because it's speech. Speech is primal. Wow. A payroll company may refuse to service woman-owned businesses because it believes the woman should not work outside the home. That one, not so much. The payroll company is providing a utilitarian thing at that point. They're just providing, there's no real speech in that. A bookseller of religious texts may come to believe it could refuse to sell books to a member of the Church of Latter-day Christ. No, not so much. No. At that point, you're not speaking. You might be speaking in choosing which books to sell, but the books are already made and printed. You're not creating new speech in the act of selling them. You know, you might have speech in so much as you choose which books to sell. We can't force you as a bookseller to sell a particular book, but if you choose to sell that book, you have to sell it to all comers because there's no speech in the selling of it. So no, these examples are absurd. Thus, that brings us to the end of this LA Times article about the stupid, about how 303 Creative's decision could swamp civil rights, and not so much. No, not so much. This is a First Amendment decision about the First Amendment, especially about the compelled speech. So can a Christian bookseller choose who not to sell to? No, not really, because there's no speech in it. You know, can an accounting firm choose who to sell its accounting services to? Probably not. There's no speech in it. Can the cake designer choose what messages to put on the speech? Probably, because there is speech in it. I'm not quite sure how they don't get this, but they don't seem to get it. And they think that this decision will, you know, end all civil rights law, which no. And they're full of dumb. And that, for the moment, brings us to the end of discussion of this case.